So about a week or two ago, I did a video about what happens to your probate assets if you die without a will as a Florida resident. The feedback I received was tremendous. As expected, a lot of people had no idea. So, since I'm also licensed in New York and I do estate planning work for residents of New York as well, I've decided to do the exact same video, going through the intestate laws for the state of New York. Why not? So here we go. And again, I am reading because I don't want to miss any of the generational steps. It's a lot, but I'm going to translate it into everyday English instead of legalese. Ready? Here we go. So, as I stated before, when you die, you have different assets that are going into different buckets, right? So your probate assets are the assets that you own individually. So think about, let's say, for example, a car that you own and your name is the only name on the title. Or maybe your house, your name is the only name on the deed. These are going to become probate assets. Now, if you have a will, those probate assets are going to be distributed among your beneficiaries in accordance with the will. But if you don't have a will, the state of New York has decided how your assets are going to be distributed. Ready? Let's go. Now, as with Florida and pretty much every state mirrors these rules, they're very similar. They might have little tweaks, little differences, but the gist is pretty much the same. Everything's going to family members, and it's going based on an order, sort of a priority of your family members. Okay, now, if you die with a spouse and no children, your spouse will get everything. Easy peasy, right? All right. If you die and you have children, but no spouse, the children inherit everything. Still easy, right? All right. If you have a spouse and children when you die, the spouse will inherit the first $50,000 plus 1/2 of the balance. The children will get the other half of the balance. Get that? Okay. Now, if you have parents and no spouse or children when you die, your parents inherit everything. I guess that works, right? All right. And then if you have siblings, that's brothers or sisters, but no spouse, children, or parents alive when you die, your siblings inherit everything. Now, it's important to know that if a child dies before you do, and the person who dies is actually referred to as a decedent, I've been skipping over that word, but I'm going to go ahead and use it. So if a child dies before the decedent, and that child had children of their own, those will be the decedent's grandchildren, right? Okay. In that instant, anytime I mentioned children in the prior priority list, those grandchildren actually will step into the place of their parents. Now, there are a few additional nuances that I think I should go ahead and point out because I don't think I mentioned them with the Florida video, but they're important too. What happens with adopted children? Okay, so adopted children are your children. So they are treated like biological children. There is no difference. So when I went down the list before, if I said children or I said grandchildren, adopted children fall into that category as well. But here's the caveat. Stepchildren and foster children do not automatically inherit. If you do not have a will, but you have stepchildren and you have foster children that you think of as your own children, it is extremely important to note that the New York legislature does not see it in the same way as you. Those children will not inherit anything unless you have adopted them, which in that case, they would be treated by statute as your biological children. Another important category are children born out of wedlock. Non-marital children are going to inherit from their father's line so long as paternity has been established. Now, this is super important because if paternity hasn't been established and we are in the intestate world, right? You didn't have a will. Your children are going to have to go through extra steps to prove that they were, in fact, your children. It is a lot of extra unnecessary work that can be avoided by simply having a will, naming them, moving on, right? Okay. And then finally, one more important note. Grandchildren, which I mentioned before, but it's very important to know. that grandchildren will only inherit under the New York state laws of intestate succession if their parents have passed away. So, again, if you want to provide for your grandchildren upon your death, you need a will, unless your children have already passed away, which is a little bit different. But do you really want to leave it up to these ifs and thens? Finally, what happens if you die and you have no family? No mother, no spouse, no children, no grandchildren, no siblings? Don't worry, New York has a plan for that too. Everything goes to New York. It's through a process called escheat, E-S-C-H-E-A-T. Everything's going to the state of New York. So let's recap. If you die without a will as a resident of the state of New York, your probate assets, which are the assets that you own solely in your name, are going to be distributed among your family members in an order of priority that has been decided by the New York legislature. If you do not have any family members, your property is going to go to the state of New York. So, how do you avoid the New York State legislature getting involved with the distribution of your assets and make sure that everything goes to the people you want them to go to? You prepare a will. Thank you so much.